notice that prior to them leaving him alone, again, hoping that you guys were peering into this while we took our break from the first half when I went to go to the new eyeglass doctor to pick up my new specs. Do you notice that what we talked about before breaking up happened? And that is that they left somebody out there to dry. And if you remember, we discussed being left out to dry once they were done taking everything out of you. If they assigned you to something, that's exactly what happened here. So let's go through this, and I'm going to fast forward with this so that we can just pull up some of the key points. But if you've seen this already and you've been keeping up, I need you to talk to us about what you saw. Tell me right now if you guys watched any of the second half since we left from this morning's 3 hours that we were chatting. Hey, Betty, I want to know if anybody saw it, because if you saw it, then what we all talked about in the morning half before we took the break, before this part started today, you will concur that if you are utilized by a group that wants to do nothing but use you, and when they are done with you, when they're done with you, they drop you like a bad habit. That's what happened here. So let me go on this side. I'm going to change the speed so that way we can keep the speed going. Playback speed, I'm going to do it at 1.5, right? Because you and I know they're going to chomp, chomp, chomp. We're going to do it at 1.5. And then what we're going to do is fast forward as we get to the pivotal pieces. Of course, because we're using somebody else's information. This is a commentary. This is a recap, a review, any other word that allows it to be utilized in a legal manner here on YouTube. Let me go through here and make sure I put everything the right way. Let me get all the buttons pushed because I just came running in the house. I just came running because I was like, I cannot believe that they just did this to this cat. If you are watching and you did see what I saw, what they did to him, boy, and he was he was a company man, this guy. All the way. He was a company man. So not only was he dealing with the opposing counsel, he's also now dealing with the prosecution. Do you see how they left him out to dry? Yeah, they left Brother Man out to dry. Yeah, they did. So here we go. I've clicked all the necessary buttons and all that good stuff. I'm back over here with you guys. Let's begin. Hey, Dark Side. It was a train wreck. They threw him under the bus. Exactly, bingo, bango. And that's exactly what we talked about, ladies and gentlemen. Before we broke earlier today, we were talking about how it is that when you take a side and you feel as if because you've now sat with somebody who is expensive or a mayor or a judge or whatever, and they appear to be on your side, that it shows you they're not, when you end up in trouble and they've already gotten out of you or extracted out of you what they needed to make their agenda successful, they will drop you like a bad habit, which is what happened to this guy. Let's get on with it, you guys. Come on. Let's go. Let's go. Correct. It's already speeded up. 1.5.
You were doing some open records requests, correct? And then based on our conversation, which open records requests are you talking about? Because I recall open records requests being made for other things, and so I don't know which one that you're referring to.
At that time, we talked about getting, I guess it's called a county card and getting access cards and things like that for coming in and out of Fulton County for you, Mr. Wayne.
Okay. And all the access that you all have. Yes. And you asked me, did I have an access card?
And you are the one that told me that you and Mr. Wayne, or that Mr. Wayne at least had an access card.
I told you that the three of us had an access card because we had a contract with the DA's office or the county. I told you what those contracts were.
I'm going to go let Buddy out of the other room, guys. He's in there whining. So you guys hold it down.
Go into a specific office.
Oh, okay.
And so we talked about that bad access card and asking for that, but I was going to ask for that, right?
Correct.
And then a couple days later,
I wish they would talk in the mic.
And when I say a couple days, so that was on September 12th when we had that conversation.
Do you mind if I pull out my phone?
On September 14th at 6:38 p.m.
Here's what I think we should do, you guys, and tell me what you think. Do you guys think that we need to pull it down to the more substantive, meaty aha moments? Because if that's the case, I would love to do that and talk to you guys about the aha moments.
Yes, and I said, wow.
Yeah, because this right here is just going to be dragging and dragging. Because here he's going to think
continue to tax
that he's got
wait.
friendship. So let's go on down here, y'all, because this thing's 3 hours. Let's see, where are we here?
I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney.
I think this is appropriate, this part right here, and where Sadao is speaking, we can possibly keep it at the normal range.
Someone, your attorney, has information which is counter or inconsistent.
Okay, let me back it up just a touch, because I think this is where they start to build. Let's go here.
And I think that this was another aspect of what came up before, which is, in my mind, even confirming the existence of the information.
You know, the best part about this,
goes
folks, is
into
we can actually take it to wherever we
implications,
want.
Whether he does or does not possess information, if it came from that relationship, that's part of the privilege as well. So if I make that clear, then
So you're sustaining what the objection would be.
That's right. It'd be sustained on privilege.
And of course, all the questions that we're
Reserved for the
talking
record.
about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we talked about.
That's right. My intent would be to make a record of the knowledge of when it was attained and the extent of it in the different sources, and that'll be sealed.
And what was actually said.
That's right.
So I guess my question to court before I sit down is, if hypothetically you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination.
Let me pause it, since this has already ended and majority of us have already watched it, which is excellent, because then we can sit and chat about it. What I want to lay as the ground basis for this is that Mr. Bradley honestly felt as if he had some type of backing based on the fact that there was a vested, in his mind, interest in keeping the information that he had shrouded under this guard of being the attorney of record. And the only person, had this gone the way that Fani Willis and Mr. Wade wanted it to go, the only person that really would have benefited from it being shrouded to the extent that they were able to keep it that way, or to use this particular defense, the only person who would have benefited, or the two people, would have been Wade and Willis. This circumstance and situation, based on what I've seen in my own personal opinion and review of this, is that the person who did not realize that he did not have the backing that he thought he had was Bradley. Not even his attorney should have told him, you need to come clean on this, and you need to let all the dates go. You need to let everything be out there the way that it is, because in my estimation, you're going to be the one to smart for this. Well, he couldn't do that. You know why? Because according to some allegations or some leading based on Miss Merchant, he was threatened. But if you noticed, the threat of violence did not even come up until going towards the end. It says it set Mr. Bradley up terribly, since most of these attorneys know one another on a personal level. Absolutely, it did. It absolutely did. And hey, here's the thing. Don't forget that all these other people that are talking to this guy, Mr. Bradley, who's an attorney, they're attorneys too. See, Atlanta, this is what I've always said about the beauty industry. When I was in the beauty industry, you know, when you work for MAC, I worked for Lancome, all these big companies that I worked for in my life. That's a big, big, big market. But when you're in a community, it's a small market. That's the same way it is with these attorneys. They all know one another. And now they just so happen to be on opposing teams. So this man knows them and they know him. He divulged information in what he thought was confidence to Miss Merchant. And Miss Merchant, as smart as she is, gobbled all the information that he gave her and retained text messages that, as you see, he did not retain. There were a couple that he deleted. And those 2 that he deleted, it's okay because she already had it. She already had it. Now, the question here is, Rich Spellman says, how is Bradley related to whom? So, Mr. Bradley is currently on the stand on this review of this from this afternoon that just ended there in Georgia. He is the former business partner of Mr. Wade, in tandem with being the former business partner, according to him and Mr. Wade. He is the attorney of record, or his attorney. And so therefore, since he was the attorney who represented him in his divorce case, he has now been shrouded because he has attorney-client privilege. But get this piece, and let me know if you guys picked this up, that May 2023, there were some documents that were signed by Mr. Bradley. May of 2023. But by Mr. Bradley's own testimony, he was no longer his attorney in the month of May of 2023. They had him admit far earlier that, I believe, and correct me if I'm wrong, or this will show us, I believe, say, for example, he stopped being his attorney in 2022, the end of 22, or end of 2021. He emphatically stated that he was not his attorney in 2023. He stopped being his attorney long before then. Ashley Merchant comes to the table and shows information in a way that proves that somebody, I think it was Sadal, could have been Sadal, then we're going to see here, that there had been a signature using his name. It was the other guy. It was the other attorney. Okay, yes, absolutely, Dark Side. I believe he said December 22-ish. That's right. So there is some evidence that shows that somebody signed his name as the attorney of record for Mr. Wade, dealing with the documentation that was put in last year. The date was May of 2023. When he went in and made the amendment about, I think it was when he made the amendment about him, not ever having a relationship with somebody and all this other stuff. This whole thing shows that the only person who is getting ringed without any permission or Vaseline happens to be Mr. Bradley. And I want to say that because Mr. Bradley is the little guy. And we look at everything based on what we said earlier today, that if you're looking at these guys as if it's the government, okay, because at one point or another, all of them have been attorneys in the government, all right, attorneys, judges, doctors, whatever, right? That the little guy in this case is going to be Mr. Bradley, because see, Mr. Bradley is sitting here trying to hold everything. He's got one foot over here, then he's got another foot trying to balance it here. He's got one finger in the dike over here, and he's got one finger pushing the buttons over here. He's losing extremities. He's losing help. He's the guy that's trying to hold it all together while all these other cats have got it in their mind that the only person that they're going to cover is themselves. They're covering their own butts. Get this now. Bradley represents the little guy. Okay? Bradley represents the little guy. And he's doing everything he can to toe the line to make sure that everything stays okay. Because I don't want to be retaliated against. They've already threatened me. And in tandem with threatening me, I don't want anybody to come back to me and say, well, you know what? He did this or he did that to me, or he lied on me. No, Bradley. They are setting you up to the point that going towards the end, now you will all of a sudden see the attorney say, well, can we kick privilege out the window? Oh, all of a sudden now his attorney wants to speak, because now he knows as a good attorney, his vested interest is to protect Mr. Bradley. Good job. Good job, attorney. His attorney did a darn good job on that point. And it was comical. Everybody in the peanut gallery wanted to laugh. As we go here, you'll see. But he protected him to the best of his ability. Now, the problem is they're going to be doing a lot of this stuff behind closed doors. And when they start to do a lot of this stuff behind closed doors, the bad thing about that is that if it's not done in public, baby, somebody going to make a visit to somebody's door. And that's the problem. When you don't do things publicly and you allow folks to know exactly what the next hand is, meaning we're going to look at all this stuff behind closed doors and just, camera and we're going to talk and it's just going to be you talking to me and it's going to be sealed after that. That's when information can get turned around because nobody has any public proof. This is in real time. This is going to be a problem. Let's go on ahead and finish looking at it.
Of whether it can be used here or whether it just remains in the record sealed.
So my intent would be to make the distinction of from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credibility determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So again, just to follow through to make sure. So if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law you provided to see if that is actually a variation of the crime fraud exception. And I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court
Hey, William.
when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified to.
And to that end, Mr. Sadout, that is something that you can, I've got this case from Ohio, but if you can find something more on point in Georgia before we schedule
Other
this
than
for
the one I
argument.
gave you,
I don't think it went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say that there's this alternative theory about fraud upon the court, but we can flesh that out in our research.
I appreciate it. Thank you.
Okay. Mr. Stockton.
No question, Judge.
Mr. Durham.
No question, John.
Mr. McDougald.
No question, Your Honor.
Mr. Rice.
No question, Your Honor.
Listen very carefully. I rather enjoyed this. I rather enjoyed
Bradley,
this.
you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel for him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on?
Say that again.
Did anyone sign your signature without your authorization on any pleading or any other paperwork
Listen
served on
carefully.
opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well.
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Judge, I would ask the court to take judicial notice of that.
For what relevance?
Judge, I think it does go directly to the crime fraud exception.
Okay, I'm gonna interject here because I want you guys to pay very close attention to the ignorance on the level of the judge. Irregardless to if something is not common federally, states have their own rules, regulations, and laws that have been set forth, no matter how antiquated they may seem or old or out of date that they are. This is apparently something that is a law in Georgia, as well as a lot of other southern states. I want you to look at how dismissive he is and how it even comes back to bite him.
Because if, before we draw objection, because if Mr. Wade was providing information to him, to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
Let me pause you there. Isn't adultery as a statute just on its face been found unconstitutional? You can't actually charge anyone with adultery anymore.
it is still current in the
Then it
state.
can't be a crime.
It's still current in the
It is
state.
Still a current charge.
Let's move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information.
Wait a minute.
We also have the January of 24 that
Have the documents I can authenticate.
Hold on.
that would be a false swearing and fraud on the court, which again is a criminal offense, and therefore the crime fraud exception would apply as well.
Okay.
I want to go back because I want to look at the pleadings.
No further questions.
Okay.
Have the documents I can authenticate my.
It does go directly to the crime fraud exception. Because if, before we draw objection, because if Mr. Wade was providing information to him, to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
Let me pause you there. Isn't adultery as a statute just on its face been found unconstitutional? You
It
can't
is.
actually charge anyone with adultery anymore.
it is still current in the
Then it
state.
can't be a crime.
Wait a minute.
It is
What
still
is he talking
Let's
about?
move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information.
Okay, I wrote down December of 23. This is February of 24. So even though he was no longer the attorney of record for Mr. Wade regarding the divorce, there are interrogatories that were entered in as recent as December 23rd. Doesn't that mean that somebody is truly a liar?
We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information, both with the original interrogatories that were filed in December of 2021, and frankly, with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense. And therefore the crime fraud exception would apply as well.
So that's entered.
Okay. Understood.
Yeah, understood.
No further
To
questions.
the point that you understood his words.
Mr. Gillen.
To the point that he understood his words. So now what we've got is another mishmash.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long day. When did you sign your engagement letter with Mr. Wade to represent him in divorce proceedings?
This poor man was wrangled into all of this.
It would have to be 2017, 2018. Same time frame, 2017, 2018.
So did you sign or have signed an engagement letter to represent him, or are you just speculating?
I can't recall. I mean, we were in we shared space. I can't recall if there was a contract or if there is a contract. I think there is a contract, but right now it would be speculation.
Right now, sitting here,
Mhm.
you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I mean, I can't say I don't have my files or anything with me.
Well, sitting here, you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? Did you open when you represent someone, you open a file in your office? And when did you open the file on Mr. Wade?
Your Honor, I am going to object to the relevance of this line of questioning. There has been no dispute by the attorney or the client that there was an attorney-client relationship. So I object to the relevance of the circumstances under which that engagement began, because as Mr. Gillen knows, that's not a factor.
And her main purpose for doing this is not to protect this witness, but rather her client. Okay, the state is not doing this for him. The state is doing this for her client. Now, in tandem with that, I want you to focus on how this guy is going to be like the little man out here in the world with the big government above him and everybody knowing each other, how he's going to be left out here by himself.
True attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we could spend too much time on this.
No,
so
okay,
we'll see.
Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it? Yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
It was a work environment, yes.
A work environment where you and him would meet and talk literally every day, correct?
Not every day, no.
Well, almost every day.
Not almost every day. I stated earlier that I ran one side of a practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So just give us totally how much money you got for representing Mr. Wade in this since 2017 or whenever you told us up until you dropped off the case in 2023.
I don't recall.
Would the answer be zero?
I do not recall.
Well, you would know whether he got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether you as an attorney got a single dollar to represent Mr. Wade, correct?
That's correct.
Because you really did it as a friend, didn't you?
No, I did it as an attorney.
Well, an attorney that wasn't being paid. You were doing it pro bono for a friend, weren't you?
And I'm going to ask me.
All right. So I'm going to sustain that, Mr. Gillen. I think the law is clear that money doesn't even have to change hands for that relationship. I'm making a finding based on the evidence that's already been presented, namely the fact that he signed pleadings, attended depositions on Mr. Wade's behalf, that attorney-client relationship.
Wouldn't it be
exists
something else
at some
Okay,
point?
I was
if he just used this man's
laying the
name and he
foundation,
never
the
had anything to do
circumstances
with it?
in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's what I was trying to do.
Okay. If the dispute is just when it occurred, you can try to hone in on that. But the questions I've heard so far are more from you were never paid ever. It's from a overall angle.
Well, from 2017 until November.
Let me ask you guys this question. Do you think it's possible that this man is simply a 110% pure fall guy in that he used his name, or maybe he used him and he did everything himself? And by him, I mean Wade did everything. Just imagine, if you will, Wade did everything himself. And this is a hypothetical. What if he did everything himself and just used his name as a rubber stamp? What if this is the reason why this man was absolutely hesitant? And what if what he stood to be a party to meant that his former partner and his friend would lose his licensure over it? And so he just decided that as long as I go along with this plan and utilize it as client attorney privilege, everybody will be fine. It'll be none the wiser. Everybody will be just absolutely okay. Think about that. Because if that's the case, then it would then lend validity to why he didn't know about any dollar amount. Because for the sake of sounding like an idiot, right? I'm sorry, I'm drinking ginger ale, so there's going to be a lot of belching. Sorry about that. It's pretty good too. It's Fever-Tree. But just for the sake of sound, see, when we hear things in part and we don't know the full story behind it, it makes the person look as if they're a little slow. But if he knows that this guy stands to lose his licensure if he exposes the fact that he really wasn't his attorney, but because they weren't always together, he had access to everything in his office, he could definitely manufacture and do everything he wanted to himself. By he, I mean Wade. And he would, oh yeah, man, okay, cool, no problem, forget about it, I got you. You guys, I think we might be on to something. I think we might be on to something. Because you would know if you got 20 cents. And if you had not made it, see, here's the thing, there's some paper somewhere that's got a number on it. Or there's a paper somewhere that has no number on it. Or there's no paper anywhere, but he doesn't know any of the three scenarios. And so he doesn't want to put his name to a dollar amount because he doesn't know about that sheet of paper. He doesn't know about the sheet of paper that says it's pro bono, or we're going to do things, we're going to cover each other. I'll take your construction case for you, which obviously, and by the way, did not come in until later. And you take my divorce case for me. We don't know if that was and he doesn't know either. And so the best thing for him to do is to make himself sound to us like an idiot and say, I don't know. You're thinking, well, why don't you know if you took any money? Because he don't know what's out there. And he don't know what this dude has manufactured. He was hoping that this whole thing would go away. And it didn't. And he knew Merchant. That's the reason why they were texting so comfortably back and forth, because they had another relationship that has nothing to do with what we are seeing here. They had a friend working relationship. They knew each other. This is Atlanta.
Of 2021, you didn't receive $1 from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago, is that it was a small firm and you were doing him as essentially a favor as a friend and as a law partner, correct?
No, I was representing him as an attorney. Were we in the practice together? Yes. And were we, or are we friends? I mean, we were friends at the time. Yes.
Well, you were friends and law partners, correct?
Yes.
And in a small firm, and I know because I'm in a small firm, people will sit around the office and talk about their social life and what they're doing, correct? Correct?
If that happens in your small firm, yes, yes.
Well, that doesn't happen, or did it happen in your small firm?
The witness has been asked very specific questions about socialization, and we've gone on through it, so I think this is asking answer.
All right, I'll let him
Well, did you in your small firm have occasion to where people would sit around and socialize and talk about what was going on in their lives as opposed to merely talking about the law.
Yes,
And you had those conversations with Mr. Wade as a friend on a social basis, didn't you?
I assume
Not yet, but it might.
yes, we talked about sports. We talked about, sports a whole lot.
You talked about life and about what was going on in your life and what was going on in his life, right? Right?
Sometimes, very rarely. Yes,
No, that's
sometimes.
what you
And
do.
that is what you do in a small work environment when you know people very well and you do favors for them, correct?
I'm going to object.
Yeah. All right. Sustain. Next question, Mr. Gillum.
Now, in that capacity, didn't you have discussions with Mr. Wade about what was going on in his social life? Did you legal advice?
Objection, need more.
I think he's just asked whether he socializes out.
I did answer the question. I said we talked about sports a lot.
And I'm asking, sports is one thing. The social life, did you talk about each other's social life, like Mr. Wade, and who he was dating?
All right. So that'll be sustained on privilege.
Your Honor, just for the record, I would state that my objection would be that the privilege only protects communications in furtherance of seeking out illegal advice, not talking about something that might be personal or confidential. And that's the distinction that I would draw.
I think that's a accurate legal point. However, I think the witness has already been questioned and testified on this point.
Thank
So next question.
Now, you got into the fact that you were the initial attorney on the divorce case, correct?
That is correct.
Now, did you and Mr. Wade, without getting into discussion, did you and Mr. Wade together prepare his responses to the interrogatories which were filed initially in the divorce case?
I'm assuming we.
Objection.
I don't think so either.
Mr. Gillum?
Well, I don't think it's attorney-client. Did they need the interrogatory answers were filed? Did he file them and do that in concert with his client? There's nothing privileged there.
Did they meet and work together, and that work taking the form of them talking back and forth to each other on the right responses?
I'll change it a little bit. Did you review yourself the interrogatory that you had when you were involved in the interrogatory responses? You had the knowledge of all that material or information that you had without getting into the content. You had all of that knowledge and information. I'm sorry, let me get my question out
That's what I
before
was trying to
he
say.
objects. And when you filed those interrogatories, you had all the knowledge and information that you had obtained from Mr. Wade from 2017 up until the date the interrogatories were filed, didn't you, sir?
Okay, so that's the follow-up question to that is going to be incorporating knowledge learned during communication. So
Oh, no, I'm not going to have a follow-up question. I just want.
Why isn't it ever just
When he filed the interrogatory form.
objection
you
and
had
then you
all the
overrule,
information
abstain, or you say objection and
that he
say
had
why?
discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
Okay, in which case, without doing that extra assuming link that he based his answers on those communications, it has no relevance.
Well, it does in the sense that it shows what knowledge he may have had when he, the attorney, is filing interrogatory responses. That's what it shows.
Okay, I'm still not seeing the relevance of his knowledge as the attorney filing the responses, unless you're linking this back to
Well,
Mr. Wade.
it gets back, Your Honor, to whether or not, if you're an attorney and you're filing an interrogatory response, which you have reason to believe, or specific information to know that certain responses are not accurate, then you shouldn't be filing them. And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up from his communications with Mr. Wade that everyone so dearly doesn't want everyone everyone to know about in spite of the allegations made against Ms. Merchant. Now,
So what if the question was, did you, when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Would there be a problem with that statement or that question?
well, I mean, I think that is a conclusion that others could draw, like the court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he's making presumptions about when information may have or not have. Bradley in his capacity.
The Voice.
Have had that information.
Mods with headlines on a voice. Would you please help this
The whole matter is
Flubart
covered
person out of the chat?
privilege.
One comment on that, Your Honor. Almost a day. Talking
Are there
about
any mods? I know I have
trying
at
to
least one.
public the dissemination of what about his relationship with Ms. Willis prior to November the 1st, 2021. And questions about discussions in 2019, all objected to the claiming the privilege. And now to say, well, that doesn't mean that he learned something after. I'm talking about what did you know at the time the interrogatories were filed? And everything that now they're claiming privilege, well, that's fine. The court will address that in chamber and in due course. What
Okay.
did you know?
I
I'm
took
sorry,
care
Mr.
of
Gillen,
them
I really
because
don't
I don't
see
have
this
any
issue.
mods
So,
on
your
headlines
question's
right
noted
now.
for the record and your objection as well.
All right, and I'll follow up with this. Now, you're leaving removing yourself from the case, the divorce case, correct? You withdrew from the divorce case, correct?
Correct.
Did you do that as a result of your concern about any of the accuracies or representations which had been made by your client in the divorce case?
No.
Okay, so that's going to cover communications during the relationship?
Well, Your Honor, hypothetically, not saying this is the case, hypothetically, if Mr. Bradley, knowing with Mr. Wade, was aware that the intimate or personal relationship, romantic relationship existed prior to November the 1st, 2021, and started in 2019 or 2020, if he's armed with that information that he's obtained from Mr. Wade, but Mr. Wade would want to insist on responding to interrogatories which were contrary to the information that Mr. Bradley would have, then I'm asking him whether he took steps as an attorney to say, I cannot be a part of that or countenance that, therefore I'm withdrawing from the case.
Sure. I still see that as covering their communications. So
I
that's
don't
the same way that-
know. But the judge should not get involved in it that intricately.
Thank you, Mr. Gillen.
Thank you.
Mr. Kucherov, are you still with us?
I feel like the judge should not get involved with that intricately because it makes him look as if he's taking a side.
Anyone on behalf of Mr. Floyd still joining us? All right, moving on. Mr. Cromwell.
Two brief questions, Your Honor. I think everybody's exhausted with this line of question, right?
We're going, Mr. Bradley. When did you withdraw from Mr. Wade's divorce case?
I don't have it in front of me. I don't have the
Can you give
file.
Was it sometime in 2023?
No, it would have probably been
Here it comes.
2023. See, I left in 2022. It could have been anywhere between July of 2022 and maybe December of it wasn't I don't have the accurate date, but it wasn't when I left. Okay, all right.
You were not his divorce lawyer at the time.
Okay.
filed in May of 2023. Is that?
Oh, no, I was not. Okay, yes.
And as of today's date, Mr. Wade is still a married man. Would you agree?
I haven't kept up with the divorce proceedings, but I think they're still open.
Okay. So, and if they're still open, that means he's still a married man.
Yes, that's correct.
So if the fact that in a pleading, there is a reference to the marriage is irretrievably broken, that doesn't mean the marriage ends, does it?
No, you
I guess
stupid. You know
ask the
better
judge
than
that's
that.
handling the case.
Well, it doesn't end until there's actually a divorce decree signed by a judge. Would you agree?
I would agree.
All right. Thank you.
Okay, Ms. Cross, were you taking?
I am, Your Honor. I'm going to have a minute. My cross-examination might be a long one. So we can go for an hour and a half. I have just a 5-minute break.
Sure. All right, we'll be back in 5.
Okay, so now they got the 5-minute break they're about to take. We're going to mute that side, and we don't have to. We can actually go back to it. Let's take the 5-minute here. Let's see, are they back yet?
Decree signed by a judge. Would you agree?
Okay. All right, they should be coming back here in a second. But while they're doing that, let's go on ahead and take a quick review of everything. So the celestial tuning system, it's heavenly, says the judge may be preserving his decision against reversal. Dark Side said the judge has definitely been in the weeds the entire time. Maybe he thought he did at Rich. So Rich says, I would ask, did you review everything you signed? That's a good question. And then you would imagine that if you could figure some of the things that would be stated, you would have brought at least some documentation with you. At least some, not all. Of course, not like you say in the weeds, not in the weeds, but certainly just the typical things like when it started. That would be something that couldn't be, that's a concrete date. It's got a concrete start date. When did it end? When did you stop? You've got that. If there was a contract, you would have that. Let's go on ahead and fast forward just a little bit here. While she's sneaking her bottle of water. All right, people are coming back in. There is Mr. Bradley's attorney. All right, she's putting on her lip gloss or chewing a piece of bubble gum now. Okay, here we go. Right here.
Coming out, Ms. Merchant, for planning purposes.
There we go.
Based on Mr. Bradley's testimony was presented, do you anticipate calling any further witnesses? All right.
He certainly did, Dark Side. He certainly did.
Thank you. Mr. Bradley, have you still got the exhibits 23, 24, 25 there in front of you?
I do.
Certainly did, solemn piece.
23. That's one of the contracts for your personal LLC or PC, your personal legal entity, right? For the
That is correct.
attorney's office? Yes?
Yes,
What?
that's correct.
Okay. And I
Yes.
understood your testimony to be that any income that came into the partnership, when I say partnership, let me be more specific. You had an individual legal entity. Mr. Campbell had an individual legal entity. Mr. Wade had an individual legal entity. Y'all had a partnership agreement, right?
Yes, but we didn't have that the entire time.
There was
Yes.
a period of time that we've been talking, that we had talked about in 2022, prior to leaving the firm, that there was an actual entity for the three of you, correct?
That is correct.
And that was roughly during the time period where y'all.
Watch this lady roll this man up like a bowling ball and hit all the pins.
Yes, correct.
And it made things simpler, or for whatever reason, you decided at that time that a joint entity made sense to own that building, right?
Correct.
Okay. All right, but those contracts there, they're not with the joint entity.
Mel, send that to me.
Those are all with you individually, is that right? You take a look at 23, 24, and 25?
Yes.
They're all with you individually?
Yes.
Okay. 23, what's the hourly rate that you were being compensated? That was a.
23 is the I don't think, no, 23 is not the first appearance. 23 is the taint, it says.
What's the hourly rate on that contract?
150 an hour.
150 an hour? All right. So the 150 an hour, the way I understand you all shared profits was you get 50, Mr. Campbell get 50, Mr. Wade get 50, and then you all pay expenses jointly as well, correct?
Correct.
What about exhibit number 24?
It seems to be the same.
Same amount?
I don't know if it's the same amount.
I'm interested in the amount. Can you
Oh,
tell me?
no, the amount was 65 an hour.
$65 an hour?
Mhm.
Right. That's not a,
Yes, that is correct.
all right. And so the $60 you're getting for that contract, again, that's split three ways, you, Mr. Wade, and Mr. Campbell, correct?
That is correct.
Wow.
So when you were being
Minus
asked-
expenses and stuff like that, but yes.
Exactly.
I don't think he knew a lot of this, but let's continue.
Income and then expenses come from that, and then profits, whatever's at the end, correct?
Correct.
All right. So when you were being asked questions about Mr. Wade, I think the phrasing, I object to that, I think you might recall the question, Mr. Wade brought you this contract, or Mr. Wade got you this contract. Do you remember those questions?
Yes, I do.
So we're talking then about a split among the three of you of about $20 a piece, right? For that particular contract?
For this one, yes,
What about 24? You got 24 there? I'm sorry, 25. You got that in front of you?
I do.
What's the hourly rate on that one?
It's 150.
150 on that one too? All right. And the same sharing went through the business, the way you handled that contract as well, right?
That's correct.
Who is Austin Dabney?
He was a probation officer that passed the bar, and we hired him and another individual. The other person didn't stay long.
And did Mr. Dabney and the other legal associate that you all had working for you at that time, did they do some work on these first appearance contracts?
Yes,
And that was a pretty good position for a younger lawyer to be sent to get some courtroom experience, correct?
that is correct.
Wow.
2020, you're aware that Mr. Wade had a serious illness during that time?
I'm aware.
And you and Mr. Wade, I think you described your relationship in a lot of details earlier about specific circumstances, but you were business partners in, let's say, up till the time you left in summer 2022, correct?
That is correct.
You were business partners up until that time.
Yes, I said yes, that is correct.
Okay. And while you didn't socialize together frequently, you considered yourself a friend of Mr. Wade at that time.
Yes, we were friends at the time, yes.
You are no longer business partners.
That is correct.
You are no longer friends.
I mean, if he's saying that we're not friends, then
I
yeah.
want to know what you think, Mr. Bradley. Do you consider yourself a friend of Mr. Wade?
I'll consider,
It goes to potential bias. Ms. Cross.
would I consider myself a friend of Mr. Wade? I would.
That's the reason why he putting his neck out for him. But watch this.
You were asked questions, Mr. Bradley, about the circumstances under which you left the firm. Do you recall those questions?
I do.
All right. And you left the firm. The firm remained the same as far as other employees, Mr. Wade, Mr. Campbell, as the main partners of the firm. You were the one who left, correct?
That is correct.
And you termed it as a disagreement. You recall answering questions as though you left due to a disagreement. Yes.
Yes,
Leading.
And that disagreement was that there was an allegation of sexual assault by an employee made against you, correct?
that is incorrect.
There was not an allegation that you assaulted that you sexually assaulted one of the employees in the firm?
These are the people he was hiding behind.
That is incorrect, but yes.
Yes, there was an allegation that you sexually assaulted a member of the firm, correct?
She's
Yeah.
going to attempt to impeach this man. She is going to enter in enough evidence to show something ain't right about him. Let's continue. I mean, you guys let me know. Is that what she's doing?
Yes, there was an allegation. Yes,
And as a result of that allegation, you left.
I did.
You were no longer business partners with Mr. Wade.
That is correct.
The firm remained intact, and in fact, the employee involved remained with the firm, correct?
I'm not certain of that. They did leave the building, of course, and I don't know. Some of the employees did leave.
Mr. Bradley, you in fact paid that employee $20,000, correct?
That is that is incorrect as far as what was. No,
On or about the time that you left the firm, and on or about the time that the allegation of sexual assault was made against you, did you pay the person who had made the allegation of sexual assault any amount of money?
there was money left in an escrow that belonged to me. I don't know what that amount was.
And did that money that was left in the escrow that belonged to you, was that paid to the employee who said that you sexually assaulted her?
I never signed any. I never gave any money. I left the money in the
But he
escrow
wouldn't
account.
have had to have done that. That would have gone through the firm's attorneys, or those who are in leadership would have decided that it made sense to take the money out of escrow to cure this incident, to cure the woman's situation. Okay. So what's going on right now is this man has been balled up, turned into a bowling ball, and he's headed down the lane right now. It could end up being a strike, but I think it's going to be a gutter ball. Let's watch.
What happened to that money? I can't. I don't know what happened to it.
For what purpose did you leave the money in the escrow account when you left the firm?
I left the money in the escrow account.
For what purpose, sir?
There was no purpose.
You just left the money in the escrow account?
Yes,
If there's no connection to the money you left in the escrow account and the allegations of sexual assault that an employee of your firm made against you, why was it that you brought to my attention? Why'd you respond the way you did about money in an escrow account when my question was, did you pay this employee any money?
And again, there's nobody to rescue him. If he is John Q. Public and he was trusting in a system the way that he was trusting in this woman, the prosecution, he was looking for the defendant's attorneys to support him. That's what I'm trying to say. He was looking for DA Fani Willis's boyfriend's people, that side, the whole team, to defend him up to this point. Why? Because they've used him to the point that they needed to. Two sides of the exact same coin.
I didn't hand any money. It was money from my escrow account, to my knowledge.
Black Spring, hey
To your
baby.
knowledge, where did the money in the escrow account go
To the employee.
to that employee?
Can you imagine his attorney freaking out over there on the
Was
side?
there one allegation or one incident of sexual assault with this employee, Mr. Bradley, or was there more than one?
It's one incident.
Or not two?
To my knowledge, there were not two incidents. No.
I'm asking for incidents that you have been involved in. Were there two incidents where you sexually assaulted this employee?
No, I didn't sexual assault anybody.
Was there another occasion where you paid any money as a result of an allegation of sexual assault against you?
No,
Did you sexually assault any clients of your firm?
no,
Never.
never.
Who's Anna Rodriguez?
I don't even know that name.
You don't recall a client named Anna Rodriguez?
Anna Rodriguez? No, I do not.
Never met her.
I do not recall the name Anna Rodriguez.
From Your Honor, I would object to this. I'm not sure what
Wait a minute. Wait.
All right, Ms. Cross.
That's Trump's attorney. That's Roman's attorney say, hey, yo, whoa, wait a minute. Wait, what gives? What are we trying to do here? Very good. That's exactly right. Yeah, what are we doing?
Right, this clearly goes to the bias that the witness has towards Mr. Wade and other individuals, his motive in
Okay.
involvement. And I believe it's an appropriate avenue to pursue based on exploring his credibility.
All right. At some point, though.
I'm not
Well,
go much further.
okay.
Wait a minute. Before she goes any further, she's exploring his credibility. And yet, when Miss Merchant and her team stood up to do their job, this lady objected every step of the way. She would not allow him to say a word. So it would appear to me that if he had been allowed to say something, it more than likely would have helped Miss Merchant's team. That's the main reason why she stood up. She did not stand up specifically to protect this man or Mr. Wade and say, objection, attorney. Her intent was to continue to prevent them from exposing specific information that she and her team would later have to try to clean up. But it's easy to throw this man under the bus. Let's continue.
Continue in this way, because you're a little bit harassing, then is Mr. Bradley going to be excused from his privilege? Because this is not.
That's what I was going to do. Don't do that.
Okay, let's back it up some. Let's back it up some, because now his attorney's finally standing up right here.
I think she's already done that.
And they find it funny.
Rodriguez? No, I do not.
Okay, look, they're laughing at this. Do you guys see this? They are all the ones who get together with their bourbon and their stogies, including him at one point or another. They are all laughing at him when he was the only one attempting to keep his mouth shut about specific things. He, with all specificity, said X, Y, and Z. He was very specific in the things that he considered privileged. His attorney was very specific in the things that they considered privileged. This woman was very specific with the things she considered privilege. Now, this man needs a volleyball that he can look at and scream, Wilson, out in the middle of the water, because homeboy is all by himself.
Never met her.
I do not recall the name Anna Rodriguez.
From Your Honor, I would object to this. I'm not sure what we're trying to do. So I would object to this.
All right, Ms. Cross.
Right, this clearly goes to the bias that the witness has towards Mr. Wade and other individuals, his motive in
Okay.
involvement. And I believe it's an appropriate
His face looks like
avenue
Wilson.
to pursue based on exploring his credibility.
All right. At some point, though.
I'm not
Well,
go much further.
okay.
Judge, if this is allowed to continue in this way, because you're a little bit harassing, then is Mr. Bradley going to be excused from his privilege? Because this is not.
That's what I was going to do. Don't do that.
Mr. Chopra.
Sit on it. I think she's already done that.
Your Honor, I'm asking in all seriousness, that privilege, although.
Based on the answer right now, I think now we've opened up a whole area. What he is just
Now they've opened a Pandora's box, is exactly what they've done. And as the attorney saw this mudslide happening, okay, or I'll reclassify it from a mudslide to absolute Chernobyl. When he saw this 110% meltdown, he should have immediately stood to his feet, and he should have immediately protected Mr. Bradley, who is still sitting there looking like the kid that nobody chose for volleyball. He's sitting there in the corner looking like, why am I always the last one to get chosen? Why am I always the last cat to know? He had no idea that what was going on was going to happen. As a matter of fact, I submit that intuitively he did know. Do you know how I say that and why? Because in the very beginning, when Miss Merchant stood up and she shared with him and everybody in that courtroom the text messages between both she and he, she at that point was his only advocate. And she should have made sure that he remained on their team. This guy doesn't have anybody to defend him. Nobody. Nobody. And now he's seeing it. And his attorney should have stood up a long time ago and stopped. He should have been saying, object. I object. Where are we going with this line of questioning, Your Honor? I object. But he didn't do that. And now it has been exposed that not only did this man lie about his reasoning for leaving the law firm, in the lie, he's now perjured himself. Do you see the ramifications that this man is going to have to, all of his actions, the ramifications of his actions are going to lead him down a path that could allow him to be disbarred. And as I submitted earlier, it was his intention to protect Mr. Wade from being disbarred because he knows he was never this man's attorney. That's my opinion and my perspective. Let's go.
Wanted to. He previously said was privilege. That doesn't sound like privilege to me. We'll have to address that when we go back through the rundown. So, Ms. Cross.
I'm finished.
Okay. Mr. Stay down.
You were accused by Mr. Wade of misconduct in the course of your representation of Mr. Wade, correct?
I was not accused by Mr. Wade, no.
Who accused you? Did Mr. Wade not, based on the questions were just asked, did Mr. Wade not bring to your attention these sexual assault allegations?
This man needs a moment and a tissue.
Ask that again, please.
Mr. Wade brought to your attention the sexual assault allegations that you've been asked about by the prosecutor, correct?
Correct.
And at that time that Mr. Wade brought those allegations to your attention, you were still the attorney for Mr. Wade, correct?
Correct.
And therefore, your conduct as an attorney and the attorney at that time for Mr. Wade was called into question by Mr. Wade's passing along to you allegations of misconduct, correct?
I object to that. I don't think that's factually true. I don't know that that's not, I know that that is not legally true. The attorney-client relationship is of a matter. It is not vitiated by other instances or anything outside that matter.
I'm not sure that that's accurate. He was accused by Mr. Wade, his client. Do you mind if I speak? I allowed you to speak.
Mr. Stay down.
Mr. Wade accused this gentleman of misconduct in the performance of activity while he's an attorney working with Mr. Wade and representing Mr. Wade. Those allegations of misconduct open up the question of whether or not he can defend himself by now discussing his confidential communications with Mr. Wade in connection with the representation as well as the allegations. That's the position of the defense.
Bingo. Bingo. And we took, ladies and gentlemen, 2 days just to get to this point. Mr. Bradley refrained from showing up yesterday. Mr. Bradley, he showed up early, but then the second time they needed to talk to him, he wasn't there. Earlier this morning, he wasn't there. He had a doctor's appointment, and then he had another guy sitting there sweating bullets, listening to the judge threaten to have, him brought in. Do we need to bring him in at this point? Because at this point, he's just, and I'm going to go ahead and paraphrase here. At this point, he's just poo-pooing us here. He's pulling our leg. He's wasting our time. Okay? He did everything that he could. He sweat bullets. He did not admit the fact when Miss Merchant brought the fact that he told her that somebody had said to him, basically, you better remember your privilege. You better remember who you are in this case, that you represent me. He denied that. He literally lied for whomever it was that was threatening him. And now he ain't got a leg to stand on because they're going to ask him, I guarantee you, are you lying now or were you lying then? Which one is it? Because either way it go, my friend, you a liar. This man has just ruined his own career. And that's so sad. But let's just hope for his case, for his sake, that karma comes back to bite the crafters of this terrible misjustice, of this terrible thing. Let's just hope that karma works on his behalf and goes back and bites those who crafted this terrible web against him.
So what is the question you're putting?
My question I'm going to ask you now is, tell us what Mr. Wade told you about when he began his relationship with Ms. Willis.
All right. So where I think we are with this is that.
And why
Mr.
is the
Bradley
judge
previously
standing
testified that
in the
the
way
reason he-
again? If you know what, if he was a dude in a club and another cat saw a pretty girl, he'd be considered a cock blocker, because every single chance this dude gets, he jumps up and he thinks that he's still an attorney. He thinks that he's still a defense attorney or a prosecutor. He continues to stand in the stead of the attorney. If the woman said objection, then let her say what she's objecting it based upon, and then let that be. The judge doesn't need to continue to do this. He's done this the entire time. And if what Mel 5.9 said, and that is that he was her clerk, this whole thing is a sham. Let me tell you, this whole entire case, if that's the case, if that is one of the fine points that we have in this, what Mel.5, let me find what you put up here, Mel. If what she said, if there's any validity to what she said, then it stands to throw the whole thing out. It can stand to throw the entire thing out. Not to mention the fact that there's already enough mud in this situation to have it thrown out. That's more than likely what's really the goal, because to me, even if they threw this thing out, there's going to be a lot of dominoes falling after this situation. There most assuredly is. There's going to be a boatload of dominoes falling. But the judge, to me, again, the same way that he did yesterday, he is blocking them from doing their job. He's been doing Fani Willis and Wade's attorney. He's been doing their job for the whole entire time. I did not have any clue that Merchant would actually submit the questions that she was going to ask this man pertinent to the text messages between both he and she. She literally gave them the questions. This is the same mindset here in our country that says every kid gets a trophy, that everybody's a winner. You got to be fair. No, when you are in a courtroom, the information should definitely be submitted, that this is the evidence. Once they've done discovery and they come up with discovery, and both of them go on ahead and they submit what each of them are going to use as evidence and a rebuttal to said evidence, that's one thing. But when do you have to tell somebody what you're going to ask the other person? And then as soon as you get on the doorstep of what you're about to ask, it startles you that the opposing attorneys jump up with opposition to what you're about to say. They all of a sudden jumping up every 5 seconds. So this judge really does need to be looked into, and I don't think that he was equipped for this. I said yesterday that they needed to move this entire situation to a totally different county. I don't understand why in her building that she works, by she I mean Fani Willis, why they would not have done a change of venue. Why did she have the ability to come running down that hallway looking like a bull in a china cabinet, hair all over her head, in that hot pink dress yesterday? Because she was in an office watching. But if they had taken this whole thing and put it in a different venue, he recused himself if there is any validity to him being her former law clerk or clerk. Okay, if there's any validity to any of this, the whole darn thing is going to get tanked, and it's a circus. All right. Not only is it a circus, but as this is going on, we still got hundreds of thousands of people creeping across our border that are military-aged men. As this is going on, we still have George Soros purchasing up large swaths of companies that were in media that could not take care of themselves and are now on the doorstep of bankruptcy. As this stuff takes place, we're still getting bills signed for 90 some odd billions of dollars and sending 40 to 60 billion over to Ukraine so that it can do a U-turn and come back to the pockets of the cats that actually wrote it. While this is going on, we're still giving $14 billion over to Israel to continue to bomb people who are now being accused of bombing somebody who has the most technically sound security in the world, to the tune of people leaning on their technical advice throughout the world to get help with their country's infrastructure as it relates to security. These are the things that we are looking at in this world right now in the United States today, while circuses like this are taking place, especially in light of the fact that we just got through seeing that just a few minutes back, Trump is guilty on something else. They just said he had to pay something else. This is a shit show, ladies and gentlemen. This is a shit show. It is a circus. Far worse than any bread and circus from back in the Roman days. This is exactly what this is. Let's continue to see where they're going with this garbage.
He left the firm was totally and completely covered by privilege. When asked by the state, he went into a factual scenario that, to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. And I think the only way I can cure that is by having that in-camera conversation with him.
May I suspend my redirect for you to have that conversation?
I think that makes sense. But is there anything else, though, that you were going to cover other than this issue?
No.
Okay. Ms. Cross, any reactions?
Only to, Your Honor, the premise of Mr. Sadow's question was that Mr. Wade accused Mr. Bradley of the sexual assault. That was not my question, and I don't believe that's factual. Though there was an employee who accused Mr. Bradley of sexual assault.
Okay. But regardless, though, the point is that the circumstances of his departure from the firm, from what I've now heard, had nothing whatsoever to do with his representation of a divorce. Is that fair?
My question, I believe the testimony has been that the circumstances of Mr. Bradley leaving the firm were related, I can't say how much, but certainly in a large part, based on the allegation of sexual assault that was made against him by an employer.
Sure. And his previous testimony was that that was totally covered by privilege.
Yes, he lied.
Okay. All right. Other than this issue, which I think we've covered at length, was there any other questions based on Ms. Cross's examination from other defense counsel? Okay. All right. With that understanding, can this witness be excused, Ms. Mershon? All right. So, Mr. Bradley, I would ask, I don't know if we may be able to do it today. If we
I'm
could.
sorry, Judge, I forgot to excuse him. Mr. Sadow had reserved the rest of his cross for after he.
Right. What I'm about to say, just logistically, is what I'm trying to do is, if we can conclude this hearing with the exception of that in-camera hearing, we end for today. And if as a result of that in-camera hearing that I learned that we need to reopen the evidence, then that's what I'll do. So to that end, I can give Mr. Bradley instructions that he's to report back if upon order of the court, but otherwise, is there anything further the parties need from him today? I know there's other housekeeping things and things we need to do.
And based on the testimony, we do have another witness, Your Honor. It doesn't involve Mr. Bradley
Right.
requiring to be here.
Okay, so now the state does have another witness.
I do.
Okay. All right. In that instance, okay, Mr. Bradley, you can step down, sir. However, I'm giving you the order to stay in touch with your attorney, and then we're going to have to find a time to meet again and go into an in-camera session. You understand, sir?
I do.
Okay. All right. Thank you, sir. You can step down. Ms. Chopra, do you have a card for me?
I do, Your Honor.
Okay.
At least I hope I do.
Terrible. The whole thing's a mess. This now when he steps away to go do his stuff to decide whether or not he's going to bring
I'm a
that
horse
witness
lawyer,
back.
I usually just tag bus stations.
It just
You can write down
reminds
your
me
contact information for us.
I will.
All right.
of
Ms. Merchant,
what
do you have any
happened the
further
night of
witnesses?
the election.
Okay.
Well, we'll pick this up tomorrow.
On the issue of the Bill Selinsky, 1006 versus 611, we're not going to call him. We think the chart, the foundation of the Selinsky chart is sufficiently in evidence, and we can just use the chart during argument under 611.
Okay. And any objection to this entry as a demonstrative, Ms. Cross?
No, Your Honor, given the parameters we discussed earlier.
Okay. Can we go ahead and mark that an exhibit and make it part of the record in advance of argument, since I don't know when we're going to be able to have that scheduled.
They better put this man on
I think this would be Defense Exhibit 28.
slit wrist watch. They better put that cat on watch.
Let me go down the order just so we're staying organized. Ms. Merchant does not have any further witness. Excuse me. Ms. Merchant, on behalf of Mr. Roman, has no further evidence. Mr. Saydown.
Your Honor, we are in the process of the court allow us to obtain certain phone records, and we would like the records kept open for the introduction of those phone records. We have them in draft. We have them informally. We do not have certification. And they will deal with, remember I asked Mr. Wade about certain activity down in Hayesville during the time period.
His servant that's exactly what I'm thinking. That's exactly what I'm thinking, because see, we really don't know what's been going on behind the scenes, as it were.
And is it your intention that you would want to introduce these solely as an exhibit, or you think that this should reopen and bring us back for an entirely new evidentiary day with witnesses?
I think that we would want to, if what we believe is there, based on our preliminary research, is there, we'd like to reopen and be able to introduce the records and someone to explain what it is.
Sure. Certainly, I'm sorry, were you finished, Mr. Segal?
I believe so.
All right.
State would certainly have an objection to that. This hearing has been set. We haven't seen the records, so I don't know if I have any objection to what they are. But the day has been set for quite a while. We object to leaving the evidence open for any purpose.
Okay. And Mr. Saydown, when did you first go about trying to obtain these records?
I know it's also the Delta records. As soon as we got a hearing date and the state's response, so what happened was when the state responded, I think it was February 9th, and admitted to the relationship that put parameters on the timing. I sent some subpoenas out in response to that, so that was February 9th. Problem is Delta, AT&T, all these folks aren't super fast about that. And so I know Delta, we're also waiting, I wanted to remind the court, waiting for those records to be submitted. And AT&T actually emailed me these phone records yesterday morning on the way to court.
Okay. All right. Any further exhibits that are self-authenticating? If counsel are able to provide those.
Yeah, maybe she
Obviously serve those on opposing counsel.
didn't want to
Before
date him
sending them
before she
over
got
to
married
us,
or something. He
let
is
us know whether they would
side
be
for her.
tendered with or without objection, just purely on authentication or hearsay issues or relevance. We can make those part of the record, and I'll reserve whether this reopens a full hearing format, but the exhibits themselves, I'm willing to have come into the part of the record. All right, cell records. Mr. Stockton, any evidence? All right, Mr. Durham, if you're still with us.
No, Your Honor.
All right, Mr. McDougald.
Certified copies I mentioned to Your Honor yesterday. Your Honor.
Okay, and why don't you lay those out for the record?
They are marked but not yet numbered. I believe our next exhibit would be 29.
28, I just said was Mr. Gillen's
Right.
demonstrative, just so I'm keeping it straight.
And so I previously provided these to the prosecution. 29 would be a certified copy of County Code Section 2-68.
Okay.
30 is a certified copy of County Code Section 2-69. 31 is a certified copy of County Code Section 2-79. 32 is certified copy of County Code Section 10-114. 33 is a certified copy of County Code Section 10-115. 34 is a certified copy of County Code Section 102-4.
Is already great. All right, do we still have Mr. Kucherov with us on Zoom or anyone else on behalf of Mr. Floyd? He's not on any longer? All right, I'm being informed that he dropped off Zoom, and so I'll make a finding that he voluntarily has absented himself from this hearing. Mr. Cromwell.
No evidence, John.
Okay. Ms. Cross, back to you.
If the defense presentation of evidence is done, I'd ask that all of the witnesses who had been subpoenaed but not called now be released.
I think that's fair. Ms. Merchant, any reason to hold on any of those witnesses? Okay.
And the state has 2 short witnesses, and that's it.
Okay, you may call your next witness, Ms. Cross.
Next witness for the state is Austin Dabney.
Okay, so Austin Dabney is the person that they asked Mr. Bradley about earlier.
Impeach the testimony of Mr. Bradley?
On collateral matter. We'll wait.
Are they going to impeach the testimony of Mr. Bradley? Wow.
Yes. My name is Austin Dabney. That's AUSTIN DABNEY.
Good afternoon, Mr. Dabney.
Good afternoon.
I want to direct your attention, well, first of all, how are you employed?
I am employed right now. I have my own firm.
You're a lawyer and you've got your own law firm?
That's correct.
Wow.
I want to direct your attention to 2021, 2022. What was your employment at that time?
Yes, I was employed with the Wade Bradley Campbell firm.
And that's Nathan Wade, Terrence Bradley, and Chris Campbell?
That's correct.
All right. And what did you do in that firm?
I was an associate attorney.
All right. And don't need a whole lot of detail, but generally speaking, who in the firm did you work for? What kind of matters did you handle?
Well, I believe I worked for all of them equally. They would all give me tasks to do, which court dates to go to, what cases to work on.
I want to direct now your attention, Mr. Dabney, to a particular instance. Did you have occasion at any time to go to a club with Mr. Bradley?
Could you repeat the question?
Yeah. Did you have any occasion to go to a club, a nightclub, or a bar situation with Mr. Bradley?
Yes, I have.
More than one time?
More than one time, yes.
The time that I'm going to direct your attention to, we spoke about a little earlier today. Do you recall any instance, Mr. Dabney, where Mr. Bradley, where you witnessed Mr. Bradley sexually assaulting him?
No, right, object to this.
Okay.
Specific instances.
Sure. All right, how is this not extrinsic evidence in a collateral matter, Ms. Cross?
Maybe ask a better question. My question will be if this witness witnessed Mr. Bradley sexually assaulting another employee of the firm.
Exactly, but same subject matter. How is that not issue on a collateral matter for impeachment?
I think it's not a collateral matter. You're on the witness denied it. I think it is highly relevant. I think that it goes to the witness's credibility and his denial here this afternoon.
Wow.
As a witness, I will proffer to the court who has firsthand knowledge and witnessed the event.
Wow.
So I think that's highly relevant to both Mr. Bradley's credibility and to the proceedings that we've had for the last 2 days.
Wow.
I understand, Mr.
Attempt to impeach Mr. Bradley, they have to live with whatever answer they can't have a sub-trial with the intrinsic evidence of misconduct here. So we would check.
Right? 24-6-608.
Hey everybody, make sure that you put a thumbs up, and for a fun way to support the channel, use the super chat or the super sticker.
Mr.
Thanks
Cross,
in
I'm just worried.
advance.
I don't see how this isn't well beyond the core facts at issue. I think you confronted with him. I think he answered them as he saw fit. An argument can be made as a result, but to go down a whole mini trial on whether he did or did not do this and circumstances of his leaving the firm, I don't see how that gets past 608.
I understand the ruling, Your Honor, disagree, and just for my objection, I put a proffer on the record, not a detailed one, but that
I think you already have.
I'd like to, with the court's permission, I'd like to make it clear that the sexual assault I'm referring to was the same employee that I asked Mr. Bradley about. I just wanted that to be clear.
Okay. All right. Understood. Is there anything else that is relevant to this witness?
Given the court's ruling, no.
All right.
Well, that was a waste of nothingness.
Questions from defense counsel?
Okay, there's more that he has to ask. Let's see what he could get out of this guy.
Good afternoon, sir.
Good afternoon.
When did you start working at the law firm?
I believe I started working, to my recollection, in March 2021.
Okay. And at that time, do I understand that there was what I would call a three-way partnership or sharing arrangement at the law firm?
I'm not aware of any sharing arrangements that they had, but it was the Wade, Bradley, and Campbell law firm.
And did you work in the law firm office on a daily basis?
I did.
And during the time period, you were there for the remainder of 2001? That is, you worked from March of 2001, at least to the end of 2001, correct?
I didn't even have a bar license in 2001.
I'm sorry, 2021, a little late. From March of 2021 to the end of 2021, correct?
That's correct.
Okay. During the time period that you were working at the law firm, did you see Fani Willis?
During my time, could you repeat the
In that
question?
time period between March of 2021 and November 1st of 2021, did you see Miss Willis?
I may have recalled one instance where I saw her in passing.
And when you saw her, was she at the law firm?
That would be correct.
And do you know who she went to visit?
I do not know.
You didn't see her go to Mr. Wade's office?
I do not recall.
Did you ever talk to Mr. Wade about Fani Willis?
Could you repeat your question?
Did you ever talk to Mr. Wade about Fani Willis during the time period of March of 2021 to November 1st?
Do you really expect him to be honest?
No.
Come on.
Did you know they were dating?
Really?
No, I did not.
Did you see anything did you ever socialize with Mr. Wade?
As far as being an employee, yes.
Well, I don't know what that means exactly, but did you ever go out to eat with Mr. Wade?
On occasion, he would take the office out to lunch.
Beyond that, did you ever go to a nightclub or drinking or any of that with him?
No, I did not.
Okay, so whatever relationship Mr. Wade had with Miss Willis during this time period, you don't have personal knowledge, correct?
I do not have any personal knowledge.
Thank you very much for being here.
Thank you.
Any other questions from defense counsel? Mr. Stockton?
He's not going to answer
When
a
you
thing.
started in March of 21, was that just you gave him a resume and started working there?
I don't understand your question.
When you started working there, is it a situation where your first day on the job is the first day you may have met him or shortly before you met him?
Again, I don't understand what you're asking.
Let me back up. Did you know Mr. Wade or any of his partners prior to March of 21?
Yes, I did.
How did you know them?
In a professional capacity. I used to be a community supervision officer with the Georgia Department of Community Supervision.
And where would that have been out of? Fulton County?
Cobb County.
How long did you know Mr. Wade prior to that?
I didn't see Mr. Wade in my professional capacity.
How long
I
did you
thought
know
were asking
him?
about all partners, but if you're only asking about Mr. Wade, if you could please clarify.
Okay, so you went to work for Mr. Wade in March of 21, correct?
I went to work for the Wade Bradley Campbell firm.
Okay. Prior to that, how long did you know Mr. Wade?
I did not know Mr. Wade prior to that
At all?
at all.
No further questions.
He just said he knew
Any other
him.
counsel? All right, seeing and hearing none. Any redirect, Ms. Cross?
No, Your Honor, subject to court's ruling.
All right, can this witness be excused?
May.
All right, thank you, sir.
Thank you, Your Honor.
Next witness, Ms. Cross.
I believe
That's
that
a
the
story
witness
in and of
proper that
itself.
The next witness the state would call would be Anna Rodriguez. Question, Mr. Bradley, about the sexual assault of Ms. Rodriguez, a client of the firm. He denied knowing her or recognizing her name. I believe Ms. Rodriguez's testimony would be impeaching of Mr. Bradley. I believe it's appropriate, but want to present that before I call her.
All right, thank you, Ms. Cross. And so, based on that proffer and the subject matter proffered, I still believe that would fall under 608B as extrinsic evidence of a collateral matter. And so I don't think it's allowed under our rules of evidence.
Understanding that, I just make a proffer on the record that Ms. Rodriguez would testify that Mr. Bradley sexually assaulted her. She was a client at the time. And that would be impeaching of his testimony that he denied.
All right, understood. Any further evidence or witnesses, Ms. Cross?
No, sir.
Okay. All right, then at this time,
Wow.
for now, I'll consider the evidence closed, subject to any certified submissions by counsel and subject to the results of the in-camera hearing. We will coordinate with all counsel to find a date to come back for summation. And to that end, again, using Ms. Merchant as kind of running lead on this, I would like you to consult on whether that's going to be a collective response on behalf of the defendants. If not, then we're going to have to get into time allotment. And if it's more than a handful of counsel, it'd probably maybe be 10 to 15 minutes per side. And so, Mr. Sadon.
When did you say this might happen?
We'll follow up by email so we can coordinate with everyone's schedules. I want to make sure we have our same court reporter as well, so that the record is all in one place. And I know we have a lot of schedules to coordinate, but looking at either late next week, as in next Friday, or the following week.
Would we at least have the opportunity to get a transcript before we do that?
I think that's probably highly unlikely, but we'll see. It's just that would require a rush, and I know again we're at a shortage of court reporters, but I think there are other means you can refer to the evidence with confidence as to what was said. Ms. Merchant. Okay. And like I said, we will. We're gonna follow up with scheduling. Mr. Gillen.
The arguments would be on this hearing.
And
Also on the forensic,
yeah, any other brought any of the filings regarding forensic misconduct?
Okay. So we see where that is. We're going to go to another situation before we close up here right now. As you can see here on the screen, which is something you probably already know, but it does tie into what we're looking at right now, the train wreck that we just got through watching, reviewing, and all of us in concert commenting on. Well, the judge who presided over a civil business fraud trial against Donald Trump on Friday ordered the former president, his sons, business associates, and company to pay over $350 million in damages and temporarily limited their ability to do business in New York. Judge Arthur Engoron, what a name, Igor Engoron, ordered the former president and the Trump organization to pay over $354 million in damages and bars Trump from serving as an officer or director of any New York corporation or other legal entity in New York for a period of 3 years, including his namesake company. The New York Attorney General's office, which brought the case, said that with prejudgment interest, the judgment totals $450 million. Quote, Donald Trump is finally facing accountability for his lying, cheating, and staggering fraud. Because no matter how big, rich, or powerful you think you are, no one is above the law, said Attorney General Letitia James in a statement, calling the ruling, quote, a tremendous victory for this state, this nation, and for everyone who believes that we all must play by the same rules, even former presidents. A ruling also bars Trump and his company from applying for any bank loans for 3 years. The decision is a potential blow to both Trump's finances and persona, having built his brand on being a successful businessman that he leveraged in his first run for president. Trump is currently running for the White House for a third time. This case is just one of the many he is currently facing, including 4 separate pending criminal trials, the first of which is scheduled to begin March 25th. Engoron also continued, quote, the appointment of an independent monitor, the installation of an independent director of compliance for the company. That is what he has moved toward and he's ordered. In posts on his social media platform, Truth Social, Trump called the ruling, quote, an illegal, un-American judgment against me, my family, and my tremendous business. This decision is a complete and total sham, he wrote. During the trial, Trump and executives at his office, including at his company, including his sons Donald Trump Jr. and Eric Trump, attempted to blame exaggerated financial statements that were the heart of the New York Attorney General Letitia James fraud case on the accounts who compiled them. In Rogan disregard. Wow. Well, it goes on to say here, there is overwhelming evidence from both interested and non-interested witnesses corroborating by documentary evidence that the buck for being truthful in the supporting data evaluations stopped with the Trump organizations, not the accountants, he wrote. The judge also cited the lack of remorse by Trump and his executives after the fraud was discovered as showing the need for a monitor. Their complete lack of contrition and remorse borders and on pathological. Boy, and it's the pathological that are saying these things. Nonetheless, I digress. Let's continue. They're accused only of inflating asset values to make more money. The documents prove this over and over again. This is a venial sin, not a mortal sin. Defendants did not commit murder or arson. So now, they did not rob a bank at gunpoint. Donald Trump is not Bernie Madoff, yet defendants are incapable of admitting the error of their ways, the judge wrote. Defendants' refusal to admit error, indeed to continue it, according to the independent monitor, constrains this court to conclude that they will engage in it going forward unless judicially restrained, he added. This guy, let me continue. Let me just go. I was about to let him have it. The ruling also bars Trump's sons, who've been running the company since their father went to the White House, from serving as an officer or a director of any New York corporation or other legal entity in New York for a period of 2 years. Trump Jr. tweeted that, quote, we've reached the point where your political beliefs combined with that venue your case is heard are the primary detriments of the outcome, not the facts of the case. It's truly sad what's happening to our country. Trump attorney Alina Habba called the verdict a manifest injustice, plain and simple. Given the grave stakes, we trust that the appellate division will overturn this egregious verdict and end the relentless prosecution against my clients, she said in a statement. A spokesperson for the Trump Organization called the ruling a gross miscarriage of justice. The Trump Organization has never missed a loan payment or been in default of any loan, close quote. An appeal in the high case would likely take years, but Trump could have to post bond for the full amount of Boy, oh boy, if he does so. The judgment is the second this year against Trump after he was hit last month with an 83 million, my God, 83 million point. $83.3 million verdict in writer E. Jean Carroll's defamation case against him. Trump has said that he plans to appeal that verdict as well, but would have to post bond for that amount as well. James had been seeking $370 million from Trump, his company, and his top executives, alleging repeated and persistent fraud that included falsifying business records and financial statements. James had argued those financial statements were at times exaggerated by as much as $2.2 billion. James contended the defendants used the inflated financial statements to obtain bank loans and insurance policies at rates he otherwise wouldn't have been entitled to, and reaped hundreds of millions of dollars in ill-gotten gains. Trump had maintained his financial statements were conservative and has called the AG's allegations politically motivated and a fraud on me. This is a case that should have never been brought, and I think we should have been that we should be entitled to damages, Trump said to the reporters while he attended closing arguments in the case back in January of this year. The months-long civil trial included testimony from Trump and his oldest children. The former president was combative in his day on the stand, blasting James as a hack and calling the judge extremely hostile. Well, you see it. That's exactly what's going on, and it's happening everywhere, wherever he is concerned. It's going to continue to happen. And the reason why it's going to continue to happen is because there has to be a narrative that's built that he has been attacked. That's the narrative that's going to be built. He's under attack and he's a sacrificial lamb, and all of the things that are going on right now are to the American people's detriment, because he'll probably say if it could happen to him, it could happen to you. And he's not lying. But the truth of the matter is that this is a giant organizational, I want to call the whole entire thing against him, even though I'm not for him. I can see, right? It is a show, but imagine if it wasn't a show. What would you consider it then? I possibly considered one gigantic conspiracy case. I mean, everybody, frankly, the whole place up there is nothing but conspiratorial. I mean, it's all like one gigantic RICO case. Everybody that sits at, over there on Pennsylvania, and then this whole situation that they're propping up against him, pulling judges out who haven't been used in a minute, who had their own secrets in their closet that everybody knows about. The whole entire thing is a mess. If this thing that went on today there in Fulton County is any indication as to how the other circuses are going, then that means this whole thing is a mess and we're in trouble. The distractions that they're putting this stuff out as a cover for all the other things that they're distracting the American people with. And for that, I'm going to recommend that everybody just stay well awake and aware of everything that's going on. I think we covered all the points that I wanted to cover as far as my commentary of what we just all witnessed together. It's a joke. It's sad. I don't even know how this thing is going to end. I really honestly don't. I think that you and I watched this for the past couple of days together, and we're going to see an outcome that doesn't even match what we saw. So with that in mind, you guys, we've been together for going on 2 hours, about an hour and 49 minutes together, hanging out again for the second time today. I appreciate each and every one of y'all for hanging out. Thank you so very much to those who have sent me cash apps. I want to thank you. Thank you. Thank you. You're a very kind person. Thank you for helping to support the channel and keep us going. All right, you guys, let's take a few of your questions. Let's put some of your questions before we leave. I don't want anyone to get ignored. So let's see here. Where are we? We would be here. Okay. Oh, yeah. So glad you're live. Well, we're glad you're here. Dude looks like Igor minus the up. Wow. Starfire Reborn. No cap, but honestly, if this level of deception is occurring at this level and with these people, non-minority people, what in the world can the average Joe expect? Very good question, Mel.5. I'm telling you, Mel 5.9, you're absolutely right. Starfire says he needs a higher horse. Her horse looks like the knees are going out. Wow. New York has no lawful rules. Well, you know what? You're absolutely right. It's the town of the lawless right now. Entire United States has become that. Dark Side 365 says New York is a cesspool anyway. Plenty of other places to do business. Absolutely. But I believe that he should have possibly seen the tide and boned out long beforehand. I think he waited a little too long to decide to leave. He should have packed up and left. The same way that Elon Musk does. You know, he packs up and he rolls out. He can see he doesn't have to have anybody tell him to get out. He just knows when to go. That's it. His servant 5 says people need to take note and flee New York City, but do not screw up our red states. Okay. You want them to stay where they are if they're not going to be content when they get here. Right. Robin says, who in their right mind would want to visit New York City, much less run a business in that city? Absolutely. Absolutely. We truly live in a banana republic. Absolutely. We sure do. We sure do. New York is a sanctuary city. They need money for all the freebies they're handing out and pocketing. That's right. That is absolutely right. Rich says a great chat, great show. Thank you so very much. And thank you, Robin, for being here. All righty. Let's see. What else do we have? Okay. Looks like we've got pretty much everybody's put in at least 1 or 2 comments we were able to share here on the screen. So I appreciate each and every one of you guys. Thank you so very much for tuning in again. We're gonna hang out either late tonight or tomorrow. I may do something. When I say late, for me, late is 10 o'clock Central, 11 o'clock Central. That's late for me. You can take me out to eat and I'll start yawning and getting sleepy at around maybe 9 o'clock. So 10 o'clock is late for me. But nonetheless, I appreciate both of all of y'all for hanging out. Both channels, both Headlines with the Voice and the Lockhart Perspective are all here in concert together. So I appreciate everybody, both the members on the Lockhart Perspective and here on Headlines, as well as all of the subscribers to both channels. Hey, if you have not subscribed to both of our channels, please consider doing so. We'd love to have you. If you are on Headlines but not on the Lockhart Perspective, hang on over there, head on over there to the Lockhart Perspective and click that subscribe button, hit the bell notification, and make sure that you like the video or dislike it. Either way it goes, it's fine with me. And conversely, if you're not over here on Headlines, do the same, won't you? If you're on the other team, you're watching over here, come on over here and subscribe as well. We appreciate y'all. Y'all take care. Be good. You hear all the noise in the background. That's nothing but Mopar, baby. 110% Dodge. Them's Dodges rolling up behind us. All right, you guys, take care. Remember to take care of my friend, darling, because my friend is you. Peace. To receive instant notification each time I upload, please hit the subscribe button and the bell notification. Helping